Spencer Mazyck, and for our fifth and final installment of our viewer's guide to the healthcare arguments, I decided to ask each of our guests if the healthcare cases will have an effect beyond healthcare proper. In other words, will the decision as to any of the issues affect more than just healthcare? And here's what they said.
Those who oppose the individual mandate argue that it is the beginning of a slippery slope, Chicken Little, the sky will fall if the government gets the power to enforce the individual mandate to buy minimal health care insurance. Then there's no stopping point. The government will be able to compel us to eat healthy food and take other steps that we would consider very intrusive. Certainly, I, as a civil libertarian, am very concerned about imposing limits on the government's regulatory power, but I see an enormous distinction between the individual mandate in this case and more intrusive regulations into matters of individual conscience, individual privacy, individual freedom of choice. And let me say that the only issue that is involved in the healthcare case before the court is whether Congress has the power in the first place to pass the law. That is only the first threshold to the constitutionality of any federal statute. Even if it is within Congress's power, fortunately, we individuals are still protected by the Bill of Rights and the affirmative guarantees of individual freedom in the Constitution that provide additional protection against government overreaching into our private lives. So I, as a civil libertarian, would not be disturbed by the court upholding the government power to require everybody to have minimal health insurance. I think that is a matter of social necessity, and I don't think individual freedom about matters of personal privacy would be threatened by that decision.
Well, I think the first answer to that question depends upon the way in which it is upheld. My guess is if the statute is sustained, what they will do is they will say that this is an insurance statute in which the subsidies from one side are necessary to require a penalty on the other side. And if you state it in that narrow fashion and talk about this plan as an integrated whole, I don't think that it will move very much further. I think the second point is, in order for the issues to come up constitutionally in a future case, somebody has to pass a legislation that's going to go beyond these boundaries. The one thing that's quite clear about this discussion is that everybody on both sides of the debate understands that Congress is already on thin ice, and that I think that most of the proponents of the legislation are trying to treat this as a unique response to a unique social phenomenon, so they're not going to move it. And the third point to make about this is if you look at the areas in which the government customarily regulates, it doesn't have to deal with these kinds of things. Environmental regulation, securities regulation, financial markets regulations, and so forth, interstate commerce regulations, none of them require that you take this. So my view about this is that for the particular statute, it's of enormous importance, but I would bet a nickel rather for or against the proposition in this way, that it's not likely in the end to change much of the character of regulation that gets through the United States Congress, and it won't change much of the regulations that get through under the new legislation that's passed. We have a plenty big government right now, and this is the one-off case. As important as it is, I don't think it's likely to be replicated.
In my opinion, I think whatever decision comes down is going to be a very narrow decision that's limited to the facts of this case, and in particular, to facts about the healthcare market. So if the court strikes the statute down, I think it's going to be a fairly narrow opinion that talks about how this statute isn't sufficiently linked to commerce to enable Congress to do what it did. And if the court upholds the statute, I think we're going to be in the same kind of territory. The court is going to say, given the unique aspects of the healthcare market, this decision stands. I think one reason for that is that the court has to get one vote in the middle either way. And I think the only way the court's going to be able to do that is to write its decision in fairly narrow terms.
This will certainly be a landmark decision, whichever way it goes. If the court finds the Obamacare legislation to be unconstitutional, then it will be an issue in the upcoming election, of course, but it will drive a stake. At least it will start rolling back the idea that Congress can do anything that it wants to do, because the court will say the Congress has gone too far. This is a bill that raises the fundamental question: does Congress have authority to do what it has done under the Constitution? Can it, in particular, order people to engage in commerce so it can then regulate that commerce under its power to regulate interstate commerce. Beyond that, if the measure is upheld, the implications are profound for our deficits, and today we're borrowing 40% of the money that we spend, and for our debts, which today are approaching $16 trillion, because no one knows how much this Affordable Care Act will cost as we work our way down the road. If the costs get too great, then of course we will start to see, as in every other country that has socialized its health care, that there will be rationing, either in the form of queues or in the form of limited prescriptions, for example, just as happens in Europe today. The other implications will be, of course, constitutional, and they will be that we live no longer under a limited constitutional government, something that we already have, but it will be finally the case. But of course, we could see the people in the upcoming election speak to that and put in a Congress that itself will eliminate this monstrosity of a bill.
Again, I want to thank our guests for their participation: Nadine Strossen, Richard Epstein, Abbe Gluck, and Roger Pilon. This concludes our Viewer's Guide, but for more information on this or other topics, subscribe to BloombergLaw.com. Thank you for joining us. Bye, everybody.